so that that's already done when we get started. And I think we may have two more pleas left. That's already done when we get started. And we'll be back 15 minutes. All right, thank you.
Thank you. Colin?
Yes, this is Colin.
Hey, would you like the case taken down?
Um,
No,
Take a
I'm
look.
just
No,
wondering.
I don't think we need that on our end.
Okay, thanks.
Thank you.
Okay, um, are you all ready?
Yes, Your Honor, if you can hear me.
Yes, Your Honor.
I can hear you both. Um, you all did want this matter taken down, correct? By the court
I-
reporter.
Yes, I do.
She may be sending you some information. Did you already do that, Miss Holloway? Exchange your information? She has it. She gave me the thumbs up. All right. This is out of Capital One NA versus Israel Smythe, case number 2024 CV 05110. This is the plaintiff's motion for summary judgment. Is the plaintiff ready to proceed?
Yes, Your Honor.
Mr. Colin Freer is representing the plaintiff in this matter. And ma'am, can you state your name for the record?
N.K. Harris for the defendant, Your Honor.
All right. Ms. N.K. Harris is representing the defendant. And you're ready as well?
Yes, Your Honor.
Floor. The virtual floor. You may proceed.
Thanks very much, Your Honor. As mentioned, I'm Colin Freer from Lloyd and McDaniel. We represent the plaintiff in this matter. This is a straightforward credit card debt case brought by the original issuer. Defendant opened a credit card with Capital One and used his card to make purchases. Each month, a statement with corresponding charges was sent to his name and address. He recognized that he owed those amounts. He made payments as they came due, but at some point he fell behind and stopped making payment. His account was charged off, meaning his ability to incur new charges was terminated in January 2024, as outlined in our complaint, which is sounds in account stated. In September 2024, as counsel, this law firm brought the complaint to recover the amount that was left due and unpaid, $6,610.14, which is reflected in Exhibit 2 to the complaint. Personal service was perfected September 22nd of 2024. Now, since then, defendant has had the opportunity to serve discovery and receive answers. This single-page complaint was the subject of 10 RFAs, 17 interrogatories, and 78 requests for production of documents. The voluminous evidence already in the record enables the court to render a judgment in this case. Now, attached to our motion for summary judgment is what I'll call the Gibbons affidavit, dated August 6, 2024. That includes and authenticates records from April 25th, 2022 to January 25th, 2024. That is the entire life of the subject account. The same day, we also filed what I'll call the Moran affidavit, which covers records spanning the period from January 26th, 2023 to January 25th, 2024, and admitted under OCGA sections 24.8.803 and 24.9.902. And as those affidavits, which are now in the record, reflect, they are admitted by custodians of records at Capital One who are personally familiar with how its records are kept at or near the time of the events recorded therein in the ordinary course of business. The case law is clear here. Capital One has met its burden, and summary judgment should be granted in its favor. As is laid out in our brief in support, these statements stand as a witness to the correctness of the account and make a prima facie case which pierces the defenses and shifts the burden to the non-moving party to prove that the items contained in the records are not correct. In defendant's response in opposition to our MSJ, the defendant argues that there is no original agreement provided among the documents in the record here. Well, that's correct. Our suit doesn't sound in breach of contract, but in account stated. It also alleges failure of personal knowledge of the events recorded in the records. It in essence challenges the admissibility of the Gibbons affidavit and the Moran affidavit. Those are questions of law, whether something is admissible evidence, not a dispute of material fact. Defendant's brief refers to the Melman case, which clarifies the applicable standard. Summary judgment is proper when the record reveals no genuine issues of material fact, and the moving party is entitled to judgment as a matter of law. That's what the business records affidavit and other documents in the record reveal in this case. And in Melman, the Georgia Court of Appeals upheld on de novo review trial court's grant of summary judgment, where the defendant, just like this defendant, had answered with a general denial and then contested the MSJ. That defendant argued, as here, that there was no evidence of a contract and that the custodian of records lacked personal knowledge of the transactions reflected in the affidavit. As the court did in Melman in trial and as was affirmed on appeal, summary judgment is appropriate. And so we are seeking summary judgment in this case for the balance of $6,610.14 plus court costs.
Okay. The case you mentioned, you said Melman?
Yes, Your Honor. The Melman case, I can give you the full citation here. I'm talking about Melman v. FIA Card Services, NA. And that is 312 Georgia Appeals 270. It's a 2011 case.
Okay.
And that's cited in our brief.
Okay. You also mentioned the suit is not a breach of contract case. It is a what?
Oh, as is clear on the face of the complaint, this sounds in account stated, which is in essence that the defendant
Accounts, what? I'm sorry.
Account stated, Your Honor. That's
Okay.
reflected on the complaint, that it is not alleging a breach of contract. It is alleging that the defendant had an account, the parties had a course of dealing where the defendant used his card to incur charges, to make purchases, received bills for the amounts due, and paid them as they came due.
Okay. All right. Ms. Harris.
Your Honor, we feel that the evidence that plaintiff is relying on in support of his motion for summary judgment is inadmissible due to its affiant, Shawanda Gibbons' lack of personal knowledge with regard to the specific account transactions related to defendant's alleged account. Throughout the affidavit, Ms. Gibbons states, according to the books and records of Capital One that she reviewed, the books and records of Capital One show the books and records of Capital One that she reviewed, basically showing that any purported personal knowledge that she had stems from her review of plaintiff's business records and that she has no specific knowledge with regard to the account. However, she goes on to state that defendant entered into the agreement and opened the account and that the account was used in accordance with the agreement, but there is no agreement supplied. The law is clear that any affidavit that is not based on personal knowledge is to be disregarded. See Jackson versus Cavalry Portfolio Services, 314 Georgia Appeals,
I'm
175.
sorry. You're talking a little fast. Slow down.
Oh, okay. Sorry
What was-
about that, Your Honor.
hang on, my court reporter. Ms. Holloway, you still there? Okay. All right. Okay, if you could repeat that case site.
Jackson versus Cavalry Portfolio Services, 314 Georgia Appeals, 175. Also, Kojo versus North Star Capital Acquisition, 298 Georgia Appeals 6. Any testimony regarding business records unsupported by the records themselves about one without personal knowledge of the events is inadmissible. Here, the affidavit and the statements contained in the affidavit are inadmissible, either because no records are attached, as there is no agreement attached, and because the records don't support the statements contained in the affidavit. Also, plaintiff has failed to establish that it has standing to sue and prosecute this action. In Ms. Gibbons' affidavit, she states that plaintiff is a successor by merger to Capital One Bank USA NA, which I'll refer to as Capital One Bank. This raises the issue as to whether Capital One Bank issued the account, and if so, did Capital One Bank transfer any account records to the plaintiff? Here, there is no evidence of any merger in the record, and that portion of the affidavit based on the Cavalry case should be disregarded as well. Also, plaintiff has failed to show that defendant entered into any agreement with it. There's no evidence of any rent terms and conditions that allegedly govern the account at issue, and plaintiff cannot support any claim for damages, account fees, late fees, or interest charges because there is no agreement showing the alleged terms and conditions agreed upon. And absent mutual assent, the contract is not binding on the defendant. While use of a card in certain circumstances may constitute assent to an agreement, this is only true where the agreement was mailed to the cardholder, the agreement was received or at least not returned as undeliverable, and the cardholder then uses the card. Here, there is no admissible evidence showing that the agreement was mailed to the defendant, that the defendant received the agreement, or that it was not returned as undeliverable, and that defendant used the card. There is a complete failure of proof to the relevant and agreed terms and conditions governing the alleged account, including how interest charges incurred, Your Honor, calculated and applied to the account. As such, plaintiff's motion must be denied. Plaintiff also failed to liquidate its damages. A grant of any specific damages is improper on summary judgment if the record does not contain sworn proof of the dollar amount to which the movement is entitled. See McGurvin versus First Capital Income Properties, 188, Georgia Appeals, 7/16/1988. Plaintiff does not provide any proof as how the new balance of $149.82 as contained on the statement attached to the affidavit for April 2022 through May 22 came to be, and thus fails to show how it arrived at the new balance of $6,610.14 as contained on this statement for December 2023 through 2024. Plaintiff's failure to liquidate its damages means that it is entitled to no damages. See Coastal Credit versus Howard, 357, Georgia Appeals, 118, 2020. Plaintiff also failed to pierce each and every one of defendants' affirmative defenses. And defendant's answer, it raised several affirmative defenses, and plaintiff failed to pierce defendant's affirmative defenses. See Peppers versus Cypherman, 153, Georgia Appeals, 206, 1980. Plaintiff does not address each and every affirmative defense pled in defendant's answer, thus plaintiff's motion should be denied. Plaintiff is also not entitled to judgment on defendant's claim for set-off. Defendant asserted an affirmative claim for set-off, which is treated like a counterclaim under Georgia law. See Gwinnett Commercial Bank versus Flake, 15 Georgia Appeals, 578. Plaintiff's motion provides no argument for granting summary judgment with respect to defendant's claim for set-off. Therefore, it will be an error for this court to dismiss defendant's claims for set-off at this juncture in the case. For these reasons, Your Honor, we feel that plaintiff is not entitled to summary judgment because of all of these outstanding factual issues that remain.
Ms. Harris, so what is the point of a business record custodian? If I guess your position is that everyone that files an affidavit from a business, it has no personal knowledge.
Well, I don't think Ms. Gibbons has any personal knowledge, and based on the case law cited, if you don't have any personal knowledge with respect to the claim set forth in the affidavit, those portions of the affidavit should be disregarded.
So I'll again review her affidavit, but what I'm saying is that if she is a business record custodian for this company, doesn't the law allow a business record custodian to prepare an affidavit and submit those records that the business relies on in court instead of, I don't know, you
If it is based on her personal knowledge or transmitted by someone with personal knowledge. But in this case, Ms. Gibbons admits that her knowledge extends only to the procedures by which plaintiff creates and maintains its business books and records. In paragraph 1, she does not state that she has any personal knowledge with respect to the specific transactions at issue here.
So if the transaction, so you're saying she doesn't have any knowledge of the transactions that
She
were,
doesn't have any knowledge
I'm
related
sorry,
to
let me finish
defendant's
my
account.
question.
Oh,
So are
sorry, Your
you
Honor.
saying she doesn't have any knowledge of the transactions that were made, so therefore she, so therefore, you know, that her disregarded?
I didn't hear your last part, you cut out.
So I said, so are you saying that because she does not have any knowledge of the specific transactions that have been allegedly made, that she does not have personal knowledge of this account?
Yes, Your Honor, that's exactly what I'm saying.
And so that would mean that each business record custodian would have to, I don't know, how does one have personal knowledge of transactions made? Do they have to be there when they make the transactions?
I guess so, Your Honor, because in Greenstein versus Bank of the Ozarks, 326 Georgia Appeal 648, 2014, the court disregarded a portion of the bank manager's affidavit that spoke of a merger between the bank that he was employed at and another bank after determining that the bank manager's knowledge stemmed from his examination of the records and that he had no personal knowledge of the merger.
You said that's 326 Georgia App 348.
No, 648, Georgia App 648, 2014.
All right. Okay, that was all the questions I had for you. Mr. Freer, do you have any other response?
Just briefly, Your Honor, to follow up on that colloquy, that the way I understand a business record affidavit is exactly along the lines that the court was just asking about. It may not be that the individual affiant was involved with the transactions that are described in the records, but as a custodian of records, he or she knows about how records are kept in the ordinary course of business, knows it to be a trustworthy process, and recognizes these documents as products of that trustworthy process. The Jackson case, as counsel quoted it, mentioned that the affidavit must be made either with personal knowledge or with attached records. That's exactly what we have here. This is not the defendant, this is not the affiant, rather, describing a rumor heard about a corporate merger. This is the affiant looking at the records and recognizing them as part of the established practices at Capital One. Speaking of Capital One, if there is anything that the court needs about whether there's a distinction between Capital One NA and Capital One Bank USA NA, then the way to remedy that would be with perhaps an order for a more definite statement. Our damages in this case are liquidated. We are suing for the precise amount reflected in Exhibit 2, and the disputed charge brought up, the $140 or $149 brought up from 2022. As to that point, as to that question, I would say that if the defendant wanted to dispute that charge, he should have disputed it 3.5 years ago. There was no dispute that I'm aware of that the defendant brought about that amount now, about that amount at the time. And so I don't believe it's appropriate to there's a good basis to bring that up only now. The business records affidavits of Gibbons and Moran reflect the records keeping at Capital One. They reflect how these went out to the defendant. They come from established processes. They're made in the ordinary course of business and at or near the time of the events recorded therein. we believe they should be admitted and that they would support a motion for a grant of summary judgment in this case. Thank you.
So, um, so at the time that the plaintiff alleges Mr. Smythe incurred these charges, who owned the account that he was using? What entity owned that account?
I would have to look at that more closely, Your Honor. I'm not well versed on the distinction, if any, between Capital One NA and Capital One Bank USA NA. And so I don't know whether that changed as to this account during the life of the account.
Well, the lawsuit was Capital One. Um, mm, I'm just looking at the complaint. Entered into credit transactions whereby defendant became indebted to plaintiff.
Yeah, I believe the account was held by Capital One NA the entire time, and that the affiants are talking about a parent company that oversees the records keeping for the plaintiff. So I don't have reason to believe that the debt was ever sold. This is an original issuer case. It's been Capital One the entire time.
Okay, that's your position. Um, what about the defense's argument that you have failed to pierce all of their affirmative defenses?
As I understand that, Judge, when we looking back to I'll cite to International Business Consulting, the Union National Bank of Georgia. This is 192 Georgia App 742. This is a direct quote, where the business records conform to the provisions of the code section, that is the code section governing business records, they themselves, the affidavits, stand as a witness of the correctness of the account and make a prima facie case, which shifts the burden of proof to the defendant debtor to show that the items contained in the books, in those records, were not correct. Stating the prima facie case pierces the defenses and shifts the burden to the defendant to introduce evidence. And the defendant has not introduced evidence that would create an genuine issue of material fact.
So you said presenting the prima facie case shifts
Supported by the business. Yes, it shifts the burden of proof to the defendant debtor to show the items contained in the books are not correct.
and that's what the case at 192 Georgia App 742 stands for. That's what you're saying.
Yes, Your Honor. And if more about this would be helpful, if you look at our brief in support of our MSJ under the header for argument and citation of authority, it's the second paragraph. It goes from the first page over to the second. Going back to the Melman case, the Melman court also held that sworn statements of the plaintiff's authorized agent combined with the reference documents were sufficient to pierce the defenses of the defendant and shift the burden to prove that our evidence is incorrect.
Okay.
If I may, Your Honor,
Yes, ma'am.
the affiant and mailman had personal knowledge, which is distinguishable from this instance because we feel that Ms. Gibbons' affidavit is inadmissible as well as the attachments attached to the affidavit. Whereas the affiant and mailman have personal knowledge of the debtor's account transactions, which is not the case here.
What was the difference between the two? Like, how do you feel as though the person in mailman had that personal knowledge and the person does not. What are the differences between the affidavits?
The court determined that it was based on the debtor's the affiant's personal knowledge, because the affiant stated that they had personal knowledge, and here
So
Gibbons did
if the
not state.
affidavit, I'm sorry, go ahead.
Oh, Gibbons did not state that she had any personal knowledge. She said that her knowledge extended again only to the procedures by which Capital One maintains and creates its business records.
Okay, I'm gonna take a very good look at the mailman case. In all of the cases presented, I've never had a credit card case that went this far, in terms of getting to a jury trial. But I I'll take a look, but it is very interesting to me. I don't think that the law requires that a business record custodian have personal knowledge of the transactions. And maybe I'm not the defense's position. Um, the records, if a company's records contains the transactions at issue and the custodian is familiar with the company's record by course of their position in the company, um, I don't understand why that's not the same thing. Is someone saying, I'm familiar with the transactions. I think they're familiar with the records that contain in which the transactions are contained, but I may be splitting hairs here. So I'll take a look at that. I thought you were going to respond to Mr. Um, Freer's argument about the affirmative defenses. Did his position is that once they establish a prima facie case that's supported by business records, that and should defense to present evidence of the defenses. Has the defense presented any evidence of their affirmative defenses to establish a jury issue?
No, because again, as you said that you will take a deeper look into, we don't feel that the business records affidavit is admissible.
Okay. All right. Anything else? Mr. Freer, you get last word on your motion. Anything else?
No, Your Honor. I agree that requiring any offender in the admission of a business record to have had personal knowledge of that specific transaction would run the risk of being the exception that swallows the rule. It would undermine the point of business records under the applicable OCGA sections. I'll leave it at that.
Yes, sir. I noticed on the consolidated pretrial order that was presented, that was filed in, that the parties indicated that discovery was not complete. Am I, what other discovery needs to be had?
Let's see.
1 second, Your Honor.
I'm going to pull that up as well, Your Honor. Is that it may be that we are still, let me see, still within the discovery period as a matter of default.
It's on, the order is not numbered, but it's on page 2 of the order under 5A.
Your Honor, I'm going to try to retrieve that here, but in the interest of time, I'll say I was not personally involved in that assertion, so I don't have the particulars, but I can ask my colleague who was and get back to the court with what's behind.
So I'll just say it said,
Defendant, yes, it reserves the right to file a motion to compel.
it says the plaintiff reserves the right to, file discovery request depending on the result of the motion for summary judgment. And defense preserve the right to file a motion to compel. So, okay, we'll see what happens. I'll treat you in order this week. Do have, I know this matters on the calendar starting Monday. Obviously, I don't know if you all know or not, but if we have to try this case, then you're to come in, you're on call. So no one needs to appear unless they're called in.
Okay, Your Honor.
All right. If there's nothing else, you are excused. Thank you.
Thank you.